as you see from your program, there will be 4 speakers. I do what I'm told, so I will introduce them in the order in which they appear on the program. Judge Robert Bork, Professor Lillian Bevere, Mr. Charles Cooper, and Professor Geoffrey Stone. The organizers advised me that they have told the participants that they have 10 minutes each for their introductory remarks. It would be kind, particularly to Professor Stone, if people would make an attempt to adhere to that.
Explain that, John, so that
Explain
why it would be kind to Professor Stone.
Right. I'm not sure. On second thought, forget about it. So that he'll be able to last until he gets to speak. And also, he's had a longer day than those of us who live here. Our first speaker is Judge Bork, who has had an interesting and productive career, as you all know. He's been in a number of interesting places at interesting times. I wasn't thinking so much of whatever might have caused that outburst, but I was thinking particularly about the Yale Law School faculty in the late 60s to the mid-70s and the Ford administration. I picked those 2 because they are also places that I was. No other particular reason for picking them, albeit not as Solicitor General, which of course is what Mr. Bork was. He is, in addition, one of our distinguished constitutional theorists, acquainted with a range of constitutional theories, and indeed having articulately espoused a number of them, if I may say that, ranging from a 1968 article in Fortune magazine actually defending substantive due process and Griswold against Connecticut. At least it had Bob's name on it. What I think of as a brilliant article in 1971 in the Indiana Law Review, which certainly influenced my own work a lot, indicating that constitutional rights are properly derived in 2 ways, one from the document, specifically defined rights, and the other, rights that can be inferred from the governmental processes established by the Constitution. I managed to blow that thought up into a book, and he manages to have abandoned that thought. So having read what I did with it, he reconsidered its validity. More recently, I think his writing has focused more on the first of those ways of defining rights, namely limiting himself to a substantial degree to rights that are more or less specifically provided for in the Constitution. He is, of course, one of our great constitutional theorists and judges from the Court of Appeals for the District of Columbia Circuit, the Honorable Robert Bork.
Thank you. As Dean Lilly has pointed out, much of my career has been spent in taking back what I said before. And so I don't intend to say anything tonight I could have to take back. And fortunately, the topic as described is open enough to allow for any remarks, which is just as well, because after spending the evening trying to follow the map that the Federalist Society provided, I've been driving about in the rain and jumping out and asking people where the law school was. They all professed that they didn't know. And I guess the map was drawn in the best tradition of the libertarian wing of the Federalist Society. Well, in any event, I intend to keep my remarks inchoate, if not incoherent, because I think it's very impolite to structure a topic so that the other speakers are confined in any way. And Dean Ely has been kind enough to mention my past writings, such as the article in the Indiana Law Review, which I've been confirmed twice now, and I've had to eat that article page by page both times. But I will now proceed to the inchoate remarks. The First Amendment, in a very real sense, is the key amendment. It's the bellwether amendment. I suppose it's the amendment in which most clearly we have the struggle about the philosophy about the proper relationship between the individual and the society. And therefore, usually First Amendment jurisprudence or First Amendment scholarship, which are not always the same thing, reflects the current balance of opposing philosophies about the role of the individual and the role of the state or the society. And I think Harry Calvin was entirely correct in saying that free speech is so close to the heart of democratic organization that if we lack an appropriate theory of the First Amendment, we really don't understand the society in which we live. And I guess the key issue now, in a way, or it has been for some time, is the degree to which the First Amendment will turn out to be about political processes, about the processes by which we govern ourselves, or will come to focus on the capacity of the individual to express his or her self. Is it a political process amendment or is it a self-expression amendment? And we don't know. And that's kind of odd after all these years. In fact, that's an odd thing about constitutional law generally. The constitutional law has very little theory about itself. And a gentleman I saw here a while back, George Stigler, gave me permission to quote him. In fact, he said I had permission to misquote him if I wished, because he misquotes himself all the time. But he once said, in a moment that I found uncomfortable, that you lawyers have nothing of your own. You borrow from the social sciences, but you have no theoretical core of your own. And I think a few scattered insights to be found here and there, he was by and large right, which is why constitutional law is constantly catching cold from the fevers of the larger society. The intellectual fads that are taking place tend to move, perhaps 20 years later, tend to move into constitutional law, and there's very little resistance from a theoretical structure of the law itself. So it's almost inevitable in our current deplorable state of theory that the law should seem to follow the zeitgeist rather than any internal logic of its own. And of course, the zeitgeist is not a single thing, but the zeitgeist I'm talking about is primarily that of the intellectual classes, which have a disproportionate influence upon constitutional developments. And I think that may be the reason that the First Amendment often seems more attentive to self-expression, which is another way of saying the privatization of morality, and less to the preservation of free political processes, because I think those are currently the viewpoints of the academic and intellectual classes. The law itself I don't intend to spend much time talking about, but the Supreme Court, I think, has from time to time suggested that it really is much tougher when it's protecting individual self-expression, whether that be pornography or whether it's subversive advocacy or something else, than it is about preserving the central core, that is the freedom of political processes. Others on this panel know more about that than I do, but I was struck, for example, in Buckley against Vallejo at the almost lighthearted way in which the court allowed really heavy regulation of political speech and particularly heavy regulation of political contributions, which it didn't seem to think important. And in fact, it allowed limitations of individual contributions so low that many people were effectively excluded from the political process. Anybody who didn't want it known, a university president, somebody of that sort, that he supported a particular political side, was really forbidden from contributing much of anything without being having that exposed. And the political corruption rationale is very odd, and the court is very soft on it, because the amounts that are regulated are so far below anything that could be expected to result in purchasing anybody's vote on an issue. And indeed, the court justified what it did by saying it had to uphold regulations on contributions on the theory that it had to prevent the appearance of corruption, which is an odd thing. If there are some people who are so suspicious that they think a contribution over $1,000 somehow does something to a presidential candidate, we have allowed a very weak rationale to control what is symbolic and important political speech. It's something akin to the heckler's veto. If there are people out there who are suspicious, the speech or the political conduct can be regulated. But in any event, what I really wanted to say is that I think the court has wavered in its devotion to the idea of free political processes. I think Buckley against Vallejo was not a major victory for those of us who think that, in fact, it was a major defeat for those of us who think that political processes are the core of the First Amendment and should be left wide open. But indeed, I think if one looks at the academic world, one sees that strain of thought even more strongly. I don't know, I'm always of two minds about how important the academic world is. But they may be the future. And if the future of the law is in the hands of that group, I think there is reason for worry. I would suppose that most, or at least the most vociferous constitutional theorists in the First Amendment area are probably advocating first judicial deference to congressional regulation of the political process, and second, something we don't often think of exactly as interference with the political process, but it is, an expansive interpretation of the Bill of Rights and the creation of new rights not specified anywhere in the Bill of Rights. Now, those are also ways of interfering with the political process and, in fact, taking large subjects out of the political process in ways which the written Constitution, the historical Constitution, in no way justifies. I wonder why the academic world is that way, and perhaps it's because perhaps the democratic process is not as popular in the academic world as one might hope, because today it seems to me there's a wider gulf between the attitudes of academics and of the general American public than any time in my experience, perhaps than any other time. And if so, one would expect academics not to be wildly enthusiastic about a political process that routinely produces results they regard as terrible. And perhaps for that reason, they come to espouse theories that limit the political process. Now, in this area, doctrinal analysis is very important, but I think it's not enough. It's very important because it has some effect upon, in keeping the law honest, in pointing out that the court wavers, that academic views are inconsistent, and so forth. And it also assists those who want to be honest about law. But doctrine tends to become odd to the degree that judges and others pursue undisclosed agendas, and so that the real moving forces behind decisions are not those discussed in the decisions. I wish, in addition to doctrinal analysis, that we could get some very good economists to analyze judges and law professors. That is, we have economists who analyze, who apply economic science to crime, to the family, and to all kinds of things we don't normally think of as economic topics. And by and large, they proceed from the hypothesis of self-interest. Now, the hypothesis of self-interest is easy to apply in a market situation to a firm, to a corporation. But if the basic economic viewpoint is right, it would be interesting to have somebody of some subtlety analyze what is the self-interest of judges and see if that hypothesis explains their behavior in any degree. It would be interesting to have them explain the behavior of academics to see whether a self-interest hypothesis, either a class interest or an individual interest, most likely a class interest, explains the kinds of theories that are coming out of the law schools. I would like to know, for one thing, the simple matter, whether the non-interpretivists, who have now become at least the noisiest group of constitutional theorists, also tend to be people who advocate judicial deference to Congress in regulating speech. One would expect that they would, because a non-interpretivist who invents new rights against the Democratic majority and thus limits the political process, I would think would be somebody who would like to limit the political process through legislation devoted to equalization of political opportunity and the like. But I wish we could go beyond doctrinal analysis in this sense to find out what the correlations are in viewpoints and what might explain what I think is a very persistent and worrisome trend now, particularly in the academic world. Thank you. I have subsided.
Professor Lillian Bevere is one of our own, a graduate of what hereabouts we like to refer to as the law school with a capital T, having even worked here at Stanford and practiced law right here in Palo Alto for a time. She has evolved into one of the leading academic scholars of the First Amendment, very prolific on this general set of issues. She is the Henry and Grace Doherty Charitable Foundation Professor of Law at the University of Virginia, Professor Lillian Bevere.
Thank you. Before I begin, I've never been on a panel with Judge Bork before, and I hope he won't find it embarrassing if I tell him about this article that he had to eat so many times. When I was just starting out in law teaching, I was trying to find my way through what was even then a morass of rather noisy scholarship. And when I happened upon that piece, it was very refreshing, like a glass of water in the desert. It didn't quite quench my thirst, but it was provided considerable refreshment. So I'm grateful to you for it. Now, you know that 10 minutes is not long enough for me to say anything to you that is going to be particularly profound. So what I have decided to do is try to find something that I thought I could package in a 10-minute span. I'm not going to try to say the most important thing about the First Amendment and the political process. I'm just going to try to say the shortest thing I could possibly think of. The topic tonight, I think, is sort of suggestive in this sense. To me, it seems to imply that the First Amendment has something to say about the political process more than just free political speech. In other words, it seems to suggest that there is a connection, maybe a First Amendment mandate, that when the political process malfunctions, we should fix it. We should reform it because the First Amendment requires us to. Now, you know and are very familiar with the litany of complaints about the political process today. We all are. They're almost as familiar now as an old shoe. The political process is dominated by special interests. It's distorted by the effects of big money. The TV ads and the media campaigns are simplistic, negative in tone, and expensive. And of course, given all this horror out there that we all view every day, the call for reform seems to have become almost as familiar as the list of problems that we see. And as I was riding on the plane just this very day, it was like finding an old friend to pick up Time magazine and read about influence peddlers in Washington. And the very last paragraph came to the quite predictable conclusion that the cure for the growing power of the influence peddling PAC is further limits on campaign expenditures, I'm sure he meant contributions, and public financing of elections. What I want to talk about is the absence of a First Amendment warrant for this kind of view of the First Amendment. It may be that the political process is malfunctioning in some sort of way. I've no doubt that there's much that could be reformed in the process, but there's almost nothing that the First Amendment permits us, in fact, to do about it. Basically, what the First Amendment seems to me to say to the political process or to legislatures who are thinking about yet other worlds to conquer is keep your hands off the political process. Now, the hands-off reading is justified by lots and lots of obvious and rather fundamental textual, interpretive, and so forth arguments, which I do not intend to pursue this evening. I'm going to take a rather more practical view of why it is that when courts are confronted with this kind of legislation, namely campaign finance reform legislation or political process reform legislation, they should look at it very skeptically. And we all as lawyers know that if you can get the court to look at anything skeptically, you've won your case. My argument basically is an argument that proceeds from legislative incompetence. And the basic point is simple. It is that legislative reform of the political process won't work. It never has worked, and it never will work. Indeed, it often produces perverse results. Laws are enacted which are not merely ineffectual, but which produce effects quite the opposite of what the legislatures, the reformers, intended, or at least quite the opposite of what they said they intended. Now, this kind of legislation is irretrievably susceptible to something that can be captured in a metaphor that Dean Ely used, and that is it's just susceptible to false positives. It doesn't produce the results that it claims. I could cite lots of examples. Actually, not so many as one might think, partly because we've been wise enough as a society not to enact, until the 70s anyway, not to enact broad programs of political process reform. Those that we did enact, we didn't seem to be very serious about, and they were very ineffectual. But I will try to establish my point by what I find to be a rather poignant example of legislative failure in this regard. And that is the Federal Election Campaign Act and its limits on individual contributions. Now, Judge Bork has described a view of the court's holding in Buckley versus Vallejo sustaining those limits, with which I am in agreement in terms of basic fundamental looking at what the First Amendment says. But I think that one might also say that let's take them in their own terms and let's assume that, well, maybe they breached the First Amendment, but maybe they accomplished some good purpose. There were two basic purposes that were announced for the individual contribution limitations. One was that it was going to reduce corruption. As Judge Bork suggested, the limits were so low that it was like sending a howitzer to kill a rat. You just don't need to have limits that low in order to reduce corruption or even its appearance. But more important, I think, dearer to the heart of the reformers was the goal to reduce the influence of wealthy persons and to enhance the influence, and this is the more important, to enhance the influence on the political process of the average unaffiliated citizen. There are lots of bad effects of that legislation, but the saddest, it seems to me, is that it has had exactly the opposite effect with respect to the influence of the average unaffiliated citizen. There is a fairly well-established, at least people who seem to know how to study these things seem to be pretty much in agreement on this point, that the growth of political power and influence of the Washington-based special interest groups, which are now, of course, in danger of being reformed, is directly attributable to the That growth was natural because those Washington-based special interest groups developed a comparative advantage of raising small amounts of money from lots and lots of people. And if you can develop that under the present scheme, naturally you're going to have considerably more political power than you did under a previous system. There's been a concomitant reduction in the ability of political parties to function. That too is now liable to be fixed in this way and that by new proposals for reform. More importantly, perhaps, the limits on contributions place a much higher burden on the ability of challengers to raise money than it does on incumbents. What this means, of course, among other unfortunate consequences, is that incumbents are ever more isolated from effective political challenge from their members, from their constituents back home. And that cannot be viewed, I think, in a systematic way as a good result of anything that calls itself political process reform. Of course, you can anticipate that perverse results will flow when you let politicians reform the political process. It is rather like letting the fox guard the chickens. But at least the fox knows what the real dangers are. But there are other reasons why campaign or political process reform, I think, tends not to work. And there are reasons that you don't have to be cynical, I think, to find persuasive. One of them is that these laws, like any laws that are enacted, become awash in unintended consequences just as soon as they are enacted. It is impossible to predict the way people are going to behave in the political process once the new scheme of rules is laid out before them. And not only can you not predict the way they're going to behave and sort of readjust and attempt to reacquire the political power that they've just lost, not only can you not predict that, but you can't in turn predict the effects that that will have down the line and so on and so forth. And pretty soon you've got a whole new reallocation of political power, which you find yourself having to fix again. But all of these things just simply cannot be anticipated, and thus to pass legislation to try to fix and make static at any one point in time seems an enterprise doomed to failure. There's one more point I'd like to make, and that is that it's understandable why political reform legislation doesn't work, simply because the stakes in the political process have become enormously high by virtue of the fact that the government has so much to do. Those who have undue influence and the lobbyists who are hired by them, if you choose to call it undue influence, please put it in quotes, they can't afford not to be deeply and as effectively as they can be involved in the political process. There simply is too much at stake. So when you regulate one form of their political behavior, they're going to find another way in which to exercise influence. And you might not know what it is, I don't know what it is, but they will find it because they have to find it. And the only way you will prevent them from finding it, and more than that, it will be a perfectly legal and legitimate way. The only way you could stop people from attempting to try to influence this process to their own betterment and to the betterment of what they see as society is to wipe out their political freedoms entirely. And I don't think anybody in this room is interested in doing that. So the short of it is for me that politics is inevitably a rough game. The political process is a very rough place in which to engage, but it always was and it always will be. And I think we should just, and the First Amendment, I think, tells us to just let it be. Thank you.
I think we should take a vote on whether Bob should be allowed to repudiate his 1971 article.
Again?
Our next speaker is Charles J. Cooper, who is the Assistant Attorney General in charge of the Office of Legal Counsel, a graduate of the University of Alabama Law School, where he served as editor-in-chief He then went on to clerk for Judge Roney on the Fifth Circuit and for Justice Rehnquist thereafter. Practiced in Atlanta until 1981, at which time he joined the Justice Department, where he's held several positions, culminating in his present one, which is, of course, one of the most prestigious in the Department of Justice, the Honorable Charles J. Cooper.
I think that's the first time I've ever heard in 4 years my employer described as anything other than the Reagan Justice Department. But I am from the Justice Department, and therefore I am morally obligated to focus my remarks on original intent. Now, those of you who are familiar with the recent debate ignited by the Attorney General's speech on the jurisprudence of original intent will agree that my enterprise is not without risks. For when one resorts to such things as the text of the Constitution and other less direct evidence of the framers' intent, one is sure to hear that the framers' intent is unknowable and in any event irrelevant to the complex needs and problems with which 20th century man must cope. Now, we might call this the I'm okay, you're okay school of jurisprudence. From the critical legal studies, people might come the edifying contribution that every decoding is an encoding. This we might call new wave jurisprudence, or punk law. But I think that any outfit calling itself the Federalist Society is willing to accept such risks as this. So let's cloak arrogance with a little humility here and treat ourselves to some facile historicism. Now, since this is an exercise in the jurisprudence of original intent, the story must begin, of course, 2 centuries ago. You will recall that the supporters of the original unamended Constitution, they called themselves Federalists too, argued that a Bill of Rights was not necessary because the federal government had not been granted the powers on which such a series of restraints would operate. Now, on the question of power to regulate the political process, however, the Constitution quite explicitly limited the federal role, leaving very little for the First Amendment to restrict. So in turning to the text of the Constitution, let's look first to the voter qualifications for federal elections. With respect to elections of House members, Article 1, Section 2 is unambiguous. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. Now, there's no congressional role there, and so there's nothing that the First Amendment could limit. The Senate, of course, is chosen by state legislatures. Remember, this is 1791. And not even the most generous constructions of the commerce, necessary and proper, and general welfare clauses could get you a federal power to determine the qualifications of state legislators. So even if we skip ahead 120 years to the days of popular senatorial elections, the 17th Amendment adopts a voter qualification provision that is identical to that provided for the House. So Congress, and therefore the First Amendment, is simply out of its own voter qualification picture. As for presidential electors, Article 2, Section 1 says this: each state shall appoint, in such manner as the legislature thereof may direct, a number of electors equal to the whole number of senators and representatives to which the state may be entitled in Congress. So much for any congressional power over voter qualifications, and so much for any need for First Amendment analysis. Next, let's look to the manner of conducting federal elections, that is, the manner of conducting them. Here, the framers were a bit more generous to Congress. With respect to congressional elections, Article 1, Section 4 prescribes that the times, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. but that Congress may at any time, by law, make or alter such regulations, except as to the place of choosing senators. Now, this was a controversial provision at the time of the adoption of the Constitution, and the purpose of the compromise it embodies is quite plain. States are in the best position to set election rules in the first instance for the convenience of local voters and the legislators, but a national oversight power was necessary as a defensive mechanism. Hamilton, in Federalist 59, noted the limited purpose and scope of this provision. Nothing can be more evident than that an exclusive power of regulating elections for the national government in the hands of the state legislatures would leave the existence of the Union entirely at their mercy. They could at any moment annihilate it by neglecting to provide for the choice of persons to administer its affairs. Well, I think it's safe to say in 1986 that any fear entertained by the founders that the states would annihilate the federal government was unwarranted. Of course, the framers envisaged Congress passing election laws only sparingly when the national government itself would be directly affected. So Congress does have explicit legislative authority with respect to the manner of conducting congressional elections, and there is accordingly some scope here for applying the First Amendment. But since the matter will be in the state's hands in the first instance, the First Amendment First Amendment issues in this area might warrant a law review Article 2, but probably not a whole lot more than that. Last comes presidential elections. Now, we saw earlier that qualifications are committed entirely to the states, but Article 2, Section 1 allows Congress to determine the time of choosing the electors and the day on which they shall give their votes. Even Congress would have a hard time finding a way to exercise this power in a manner inconsistent with the First Amendment. So we leave 1791 with a definite sense that First Amendment litigation of the political process at the federal level is not going to burden the caseload of the federal courts. And of course, for most of this country's history, it didn't. Obviously, something happened between 1791 and 1986. First, and this may not come as a surprise to some of you, the courts have given a broad reading to Congress's powers. And I use the word reading rather loosely here. In Ex parte Yarbrough in 1884, the Supreme Court upheld Congress's power to pass criminal laws protecting the right to vote in congressional elections. Now, the court invoked Congress's power to regulate the time, place, and manner of congressional elections. And since the victim in that case was black, it also invoked the 15th Amendment. Now, one could in fact support such a power under either of these provisions, but the court relied on neither of them specifically. The punchline came near the end of the court's opinion. But it is a waste of time to seek for specific sources of the power to pass these laws. The court's reasoning boiled down to the proposition that Congress must regulate, so it must have power to regulate. The court invoked this reasoning, if that's what it was, 50 years later to uphold the disclosure requirements for presidential campaigns in the Federal Corrupt Practices Act. The Supreme Court pronounced the language in Yarbrough broad enough to extend beyond congressional elections and concluded that because the presidency is an important office, Congress must somehow have the power to regulate presidential elections. And how did the court handle the textual commitment of the subject to the states? Well, since the statute dealt with multi-state political committees, its operation, and this is language from the court, is confined to situations which, if not beyond the power of the states to deal with at all, are beyond its power to deal with adequately. Now, sympathetic constitutional scholars would call this a living and a growing constitution, able to adapt to modern exigencies. The Constitution has continued to live and grow, consuming additional territory in this area. In 1941, in United States against Classic, the court permitted federal regulation of primaries and thus overruled its earlier decision to the contrary. And in 1970, in Oregon versus Mitchell, 5 justices found congressional power to establish the 18-year-old vote in federal elections, 4 under the Enforcement Clause of the 14th Amendment, and 1, Justice Black, in the text of the Constitution. That's right, the text. Justices Douglas, White, Brennan, and Marshall even found power in the 14th Amendment for Congress to set age qualifications for voters in state elections. Well, in any event, by the time of the post-Watergate election laws, when they came to the Supreme Court in Buckley against Vallejo, the court could unexcitedly observe that the constitutional power of Congress to regulate federal elections is well established and is not questioned by any of the parties in this case. That's hardly a surprise. That left the Buckley court to treat with the First Amendment issues that remained. And since that time, the Supreme Court has, of course, occupied itself with determining the First Amendment limits on various exercises of this highly dubious congressional power. But this case law development and the resulting expansion of federal power only accounts for a relatively modest portion of the First Amendment litigation involving the political process. The bulk of modern cases involving the First Amendment and the political process don't even involve the First Amendment, really. They involve the 14th Amendment. Most of the laws regulating political processes are state laws, subject to the First Amendment scrutiny by virtue of that amendment's so-called incorporation into the Due Process Clause of the 14th Amendment. Now, the question whether the framers and ratifiers of the 14th Amendment intended the First Amendment's protections to be made applicable to the states has been hotly debated since the Supreme Court assumed the proposition in Gitlow versus New York. And this is hardly the time to resolve it, but Professor Philip Kurland has said this on the question. Whoever looks to the history of the formulation of the 14th Amendment will search hard and long without success for any indication that protection of free speech or free press was to be effected by the promulgation of the Due Process Clause of the 14th Amendment. Clearly, it had not been considered a part of the same language in the Fifth Amendment. Now, if Professor Kurland is correct, and he's joined in his view by a host of very substantial constitutional scholars, the intent of the framers with respect to the political process has been hit by something of a double whammy. The power to regulate the federal political process, which the founders assigned largely to the states, has gradually been drained off by the Congress. And the regulatory authority that the states have managed thus far to retain is subject, by virtue of the incorporation doctrine, to the strictures of the First Amendment. Now, this state of affairs has more than mere historical significance, for it places external and sometimes very rigid constraints on the ability of the states to experiment in the area of politics and government. It is now cliché to speak of the states as laboratories, but nowhere is this as true or as important as in the field of government process, where the right system within the framework of republicanism required under Article 4 might be discovered only in light of experience and local circumstances. Given the framers' quite proper emphasis on process and structure, it is not too much to say that imposing strict uniformity on state political processes does violence to the principle of federalism in a way and to an extent that nationwide uniformity in other areas can never approach. All of this leads me to the conclusion that there is much merit in the view held by Justice Rehnquist, as well as by his predecessors in that seat, Justices Harlan and Jackson, that the First Amendment should be applied more stringently to federal than to state regulations of the political process. And this view derives principally from the proposition that the First Amendment's applicability to the states is somewhat limited, including only those restrictions necessary to protect the core values of the amendment. Applying the First Amendment stringently to federal regulation of the political process would limit Congress's role in the area and thus better comport with the plan of the founders, at which, as we have seen, did not contemplate much role at all for Congress. On the other hand, less stringent First Amendment review, something perhaps along the order of a rational basis, of state election laws would permit the states latitude to experiment and thus to test a variety of solutions to the problems they may detect in their own political processes. This approach, while a good deal less than a wholesale return to original intent, does inch us a little bit in that direction. It may also provide some useful insights to solving some of the problems that vex 20th century man. Thank you.
Our final speaker is Professor Geoffrey Stone. He did not clerk for the same people that Mr. Cooper did, but rather, or I suppose for people on whom the students in this room are likely to have their sights set. He clerked for J. Skelly Wright, and following that for Justice William Brennan. Since then, he's been at the University of Chicago teaching. He is a distinguished graduate of that law school. He holds the Harry Calvin professorship there, which is fitting since Mr. Calvin was a very distinguished First Amendment scholar, as is Mr. Stone. Our final speaker, Professor Geoffrey Stone.
Every panel needs the theme. It seems to me the real theme of this evening's panel is Judge Bork's 1971 article in the Indiana Law Review. Professor Bevier said that she was grateful for that article, and I am grateful as well. As the author of a soon-to-be-released casebook in constitutional law, I can attest that no one has ever said quite so eloquently as Judge Bork those words that he has since had to eat. And indeed, I am pleased to report to Judge Bork that the book, which will appear soon, has endless excerpts from his 1971 article, so that hopefully, if Jerry Gunther doesn't mind, generations of future law students will continue to have the opportunity to chew on Judge Bork's words. I would like to talk this evening about the Supreme Court, about free speech, and about participation in Professor Milton Friedman's marketplace of ideas. In the past decade, the Supreme Court has engaged in a highly selective form of judicial activism in its evaluation of the constitutionality of restrictions on political expression. Limitations on political expenditures, whether by private individuals, by corporations, by political committees, or by political candidates, have been tested by extraordinarily demanding standards of justification and have almost invariably been held unconstitutional. In Buckley versus Vallejo, the court invalidated provisions of the Federal Election Campaign Act, imposing limitations on the amount of money individuals and political candidates could spend in the course of political campaigns. In the Bellotti case, the court invalidated a Massachusetts law limiting the amount of money that corporations could spend to promote political causes. In Federal Election Commission versus NCPAC, the court invalidated a provision of the Federal Election Campaign Fund Act limiting the amount of money that PACs could spend in promoting presidential candidates who accept public financing. In these and similar decisions, the court has strictly scrutinized restrictions on political expression and given no deference whatever to legislative judgment. Now, in a contrasting set of decisions involving restrictions on other forms of political expression, the court has applied an extraordinarily deferential standard of review. Indeed, once one moves beyond the specific context of cases like Buckley, Bellotti, and NCPAC, the court in recent years has consistently and almost without exception upheld restrictions on political speech. In Lehman versus City of Shaker Heights, the court upheld a city policy permitting commercial but not political advertising to be displayed in city buses. In Greer versus Spock, the court upheld a rule prohibiting individuals wishing to communicate with soldiers from entering even the otherwise wholly public areas of a military base to make speeches on political issues. In the Heffron case, the court upheld a Minnesota State Fair rule prohibiting all peripatetic leafleting on the grounds of a state fair. In U.S. Postal Service versus Greenberg Civic Associations, the court upheld the Postal Service rule prohibiting community groups from leaving flyers and other informational material in letterboxes. In the Vincent case, the court upheld a Los Angeles ordinance prohibiting the posting of signs on public property as applied to individuals who tied political campaign signs to public utility poles. In the Metro Media case, a majority of the justices addressing the question voted to uphold a ban on all billboards, including those displaying political messages. In the Cornelius case, the court upheld an executive order excluding from the federal employees' charitable fundraising program any otherwise eligible organization if it engages in political advocacy. Now, my concern, I should note, is not that the court was necessarily wrong in its decisions in Buckley, Bellotti, or NCPAC. Rather, my concern is that the court has seriously underestimated the individual and cumulative effects of restrictions upheld in cases like Lehman, Vincent, Greer, Heffron, and the like. The court seems oblivious to the reality that many participants in the political process, in Professor Friedman's political process, particularly at the local level, do not have large amounts of cash to spend and cannot afford access to television, radio, newspapers, and other mainstream means of communication. A healthy system of free expression, a vital political process, demands that groups and individuals have access to a wide range of alternative means of expression in their efforts effectively to communicate their views with others. By adopting a highly elitist perspective, the court has increasingly permitted the constriction of such alternative means of communication. And to achieve its results in these cases, the court has relied especially on three distinct doctrines. First, the court has repeatedly maintained that the challenge restriction in these cases is permissible because adequate alternative means of communication remain available. As the court recognized in the Schneider case some 50 years ago, one is not, however, to have the exercise of his liberty of expression in appropriate places abridged on the plea that it may be exercised in some other place. There are indeed grave dangers in the notion that courts or legislators can fairly and reliably determine whether alternative means of expression are adequate for particular groups or individuals who disagree with that judgment. And although the existence of alternative means of communication is surely not irrelevant to the constitutional inquiry, it is a matter that must be approached with sensitivity and with caution. The dangers in this inquiry and the court's own failure to approach it with a sensitive and forthright attitude are evident throughout its decisions. In the Vincent case, for example, the court, in upholding the prohibition on posting political signs on public utility poles, maintained that adequate alternative means of communication remain available. And in particular, the court pointed to the ability of individuals to post political signs on private property and to distribute leaflets by hand. But those means of expression are patently less efficient and less effective than the means of expression prohibited in Vincent. The court, in truth, paid only lip service to the alternative means inquiry. The second doctrine that the court has repeatedly invoked in these decisions is the idea that content-neutral restrictions are not serious threats to free expression. Now, content-neutral restrictions as a class are indeed generally less threatening to free speech than restrictions based upon content, but the court has taken the point too far. It seems to have concluded that so long as a law does not discriminate on the basis of content, does not involve a public forum, and does not limit the expenditure of cash, it should be upheld. Even content-neutral restrictions, however, can pose serious First Amendment issues. Like content-based laws, content-neutral laws can have significant content differential effects. That is, although neutral on their face, they can skew the marketplace of ideas. As Justice Black observed more than 40 years ago, laws which hamper the free use of some instruments of communication thereby favor competing channels, and can give an overpowering influence to views of those who employ the legally favored instruments of communication. Moreover, and wholly apart from the content differential effects of content-neutral restrictions, such laws necessarily constrict the available means of communication and thus impair the vitality and liveliness of public debate. The third doctrine that the court has often relied upon embodies the idea that exclusion from non-public forum public property are permissible so long as they are viewpoint neutral and rational. In 1972, in the Granite case, the court abandoned the previously rigid division of public property into public and non-public fora and proclaimed that the crucial question in every case is whether the manner of expression is basically incompatible with the normal activity of a particular place at a particular time. In its more recent decisions, however, the court has in turn abandoned Granite and created an even more rigid and more artificial distinction between public fora, limited public fora, and non-public fora. And in practical effect, the court has concluded that except in so-called public fora, content-neutral restrictions on public property are per se constitutional. Like the discredited doctrine that predated Granite, the court's new set of categories elevates the property interests of the state to an unreasonable degree. By narrowly defining public fora, the court has effectively made all public property, other than streets and parks, off limit to free expression, so long as the state acts in a content-neutral manner. Now, having said all this, I hasten to add that I don't mean to suggest that every person should have the right to speak whenever and wherever she pleases. To the contrary, reasonable government regulation of speech is appropriate. But what is needed is reasonable accommodation, not complete constitutional abdication. In cases like Vincent and Metro Media, the state should be permitted some discretion to regulate the size, the number, the location, the appearance of signs and billboards to protect legitimate aesthetic and traffic safety concerns. But it should not be permitted to ban all signs and all billboards, and thus to completely eliminate those means of expression. In cases like Heffron, the court should be permitted to restrict the number, the location, and the behavior of leafleters in order to protect legitimate regulatory concerns. But it should not be permitted to ban all leafleters from the state fair or from other public property. And in cases like Lehman and Cornelius, once the state decides voluntarily to open its property or other facilities to speech, it should not have discretion to exclude all political expression, which after all lies at the heart of the First Amendment, merely because the court can conceive of some rational explanation for the exclusion. As Justice Roberts recognized in his landmark opinion in the Hague case some 50 years ago, the right to freedom of expression must be exercised in subordination to the general comfort and convenience, and in consonance with peace and good order. But it must not, in the guise of regulation, be abridged or denied. The court's selective activism in this context, protecting the expenditure of cash, but almost no other means of expression, is disturbing both because it fails to protect the interests of those who do not have access to mainstream means of expression, and perhaps even more important, because it reflects a blatantly non-neutral set of judgments about whose speech should be preserved. Thank you.
Before we open it up for discussion, I'll open it up for discussion by myself. By way of joining issue on what has surely been one of the central themes, not your article again, I want to say a few words in defense of the constitutionality of campaign contribution limits, at least to try to state how one might come at it in a way that suggests they're constitutional. Professor Bevier didn't mention, but I should, that she has an excellent recent article on this subject in, I suppose, just about the most recent issue of the California Law Review, suggesting, as you would gather from her remarks, that such limits are generally unconstitutional. I was particularly drawn to it since it based part of the analysis on my work, but the way things have been going for me, I expect she's probably repudiated that part of the article by now. Think about the relation of big campaign contributions to communication, and I think it's most helpful to think of it as an amplifier, that is, as adding decibels to the message that you're trying to convey to the legislator. You can convey to him or her the message in various ways, by saying it or by giving $1. Of course, when you give a much bigger gift, I don't think you're saying anything different, but you're saying it a whole lot louder when you give that much money. If you view it like that, it begins to me to seem a little bit like a regulation on the number of decibels a sound truck can emit, and I think probably we would all agree that that kind of limit is constitutional, although you couldn't tell people they couldn't say certain things, you can keep them from saying it very loud. Now, at this point, Professor Bevier will intervene, and except I won't let her at the moment, and say, I missed a stitch there, because regulating sound trucks would make perfectly good sense even if there were no communicative significance whatever to what the sound truck was doing. If it was just moaning, just waking you up with utter gibberish that was unintelligible, still it would make sense to pass this rule keeping the decibels down. On the other hand, under both her analysis and mine, this seems like a different case, because there really isn't an intelligible case for limiting campaign contributions unless what the person is saying by the contribution, or what the person doing by the contribution is conveying a message. In other words, if there were no communicative significance at all to the contribution, none of the theories of government regulation, and this is what her article argues, would make sense. So approached, I agree, in terms of the most intelligible First Amendment theory I've been able to come up with. It's a very serious problem, and they do look unconstitutional. For a moment, just to state the other side, I'd like to step back a pace and pursue an analysis that I think Professor Friedman began to suggest, although I doubt he would follow me on it at this point, and ask, well, postulate, and as Judge Bork said, it's not clear that this is true, but postulate that the reason we protect political speech is because we are concerned with the operation of a democratic system of government, and ask the question back of the First Amendment questions, why is it that we want to protect the democratic process, which involves us inquiring into, which we can't at length, why we have a democratic theory, a democratic system. There are many theories of that. To my mind, the most intelligible, and one that I suspect many people, though not all in this audience, probably would readily accept, is that democracy is sort of an institutional way of approximating a utilitarian calculation of individual preferences. That is, that it's rooted in the idea that each of us is the best judge of his or her own best interests, that nobody should say for us what it is we value and care about, that each of us, the interest of each of us is to count for one and none for more than one. Therefore, each of us gets one vote. Now, there's nothing wrong with, if you feel more intensely about something, politicking more, making a whole lot more noise, and therefore having a lot more influence. The problem, which the proponents of this legislation would point to, of course, is that money is a wildly irrational index of intensity of feeling, given that some people are much richer than others, and many of them got that way by inheriting their money. That is, that Lawrence Rockefeller and I may feel differently about some issues. We may feel it with equal intensity, but if each of us is entitled to give unlimited campaign contributions, something other than that intensity is going to be reflected in the process. That can be viewed, I think, as a perversion of utilitarianism and therefore of democracy. Now, there are a lot of debatable chains in this argument. One, that we protect political speech because we're concerned about democracy. Two, that democracy flows roughly from the same sorts of things that utilitarianism does. But if those are both true, and I think they are, I think coming at it from that more meta theory suggests that these are not such bad laws as they may seem to be. That particular law is a bad law in some ways, but putting limits on campaign contributions from that perspective makes sense. I think maybe we'll start by letting the panelists, if any, were infuriated by anything the others said, excluding my remarks. Perhaps they could speak first, and then we'll take questions from the floor directed to any or all of the panelists. Is anybody here? No one. Okay, fine. We have some microphones on the floor, and I think we will open it up for questions or arguments. Why don't you, I think you ought to step up to the microphone so that, I assume that's why it's there. Go ahead. So that the people in the back can hear you. We could hear you, but they couldn't. And if it's directed to somebody specific, why don't you say who that is?
I think my question would be more interestingly answered by Robert Bork or Geoffrey Stone, since I sense that their ideology differs from mine a hair bit more. Very simply, what is the purpose of government? Why have one at all?
Richard, where's Epstein?
Epstein is the one man in this audience who doesn't think there is any particular.
Richard is a good answer. To read the preamble.
Why don't you stop sighing and
Say something? I suppose to enable individuals to find their own fulfillment without interference by others, to let them achieve to their own greatest extent what it is that they want to achieve, without others interfering with it.
you expect me to take a swing at that?
You made me do it.
Just because you are easily pushed around. Whenever humans assemble, they form governments. They form governments with ends that suit them well. Governments are formed for very different purposes, serve very different purposes. The one we have, I think it's a mistake for us to begin to ask, every time we interpret the Constitution, what is the real end of government? We are handed a particular form of government expressed in the Constitution and in our traditions, and the problem is to make that one work without asking what is the ultimate purpose of it.
It's to protect property from the marauding hordes.
Well, the previous questioner stole my question, so I'm going to have to come up with another one now. Since at least 3 of the panelists mentioned the concept of core speech, I should probably make this an open question to the panel. What does it mean in practical jurisprudential terms to say that something is at the core of the First Amendment? It seems that something is either in the First Amendment or it isn't in the First Amendment. And whether it's at the core or at the rind, if it's anywhere in there, Congress shall make no law abridging the freedom of it, etc. And if it isn't, then Congress can make all sorts of awful laws. So in practical jurisprudential terms, what does it mean to say that something is in the core of the First Amendment?
I don't understand a statement of practical jurisprudence. And what it means is simply this: there are some things we know a concept is concerned with. As we move out, it becomes more and more debatable whether the concept includes these things. And that's all that the word core and fringe means.
The significance of it, I agree with Judge Bork there. In a sense, it means that some things are more central to, if it's the First Amendment, I think from what I gather, all of us would agree that at the core of the First Amendment is political speech. But if Judge Bork has eaten his article, I assume that means that...
I haven't eaten the article. I ate
words.
one little sentence.
Oh, which is the sentence?
I'll never tell.
Well, I would assume that most of us, however, agree that it does not protect only political speech, that there's other speech that is close enough to political speech or for other reasons may also be protected by the First Amendment. But to say that it's not at the core probably means simply that it is more subject to restriction or regulation, or on a less compelling showing of government justification could be subject to restriction than speech that is more central to the guarantee at issue. And that would apply to the Equal Protection Clause or the Due Process Clause of the First Amendment as well.
Well, if I can quickly follow, and then I will sit down. That's precisely the question I have, is how does one textually justify a distinction in degrees of protection of core versus rind speech?
Where does one determine what is the core?
Because how does one text it?
How do you justify treating them differently?
No, once I gather from your response that there are certain kinds of speech, some of which are going to get scrutinized more closely and can be justified by reference to a lesser governmental interest than others. And that's the question that it's that meaning of core speech that I've always had questions about. It's either a particular, once you have gotten past the gray areas and you've decided that something is in fact within the First Amendment, that we are talking about a First Amendment question, then Congress shall make no law abridging the freedom of it. And how does one get to the point of making distinctions once you're within the apple, once you're somewhere in the,
Well, the word
penetrating
abridging,
the skin and
neither the word abridging nor the word freedom of speech are self-defining. I mean, you're treating the word abridging, I assume, as meaning in any way interfering with, and the freedom of speech is meaning something that can never be interfered with. But that's a perfectly literal way of interpreting the First Amendment, I suppose, and Justice Black at least purported at times to adopt that. But that assumes that the words are self-defining, and I don't think anyone but Justice Black has ever really taken that seriously.
You didn't.
And he did neither.
No. You can't take it seriously.
I know the one sentence that Judge Bork ate from his article. It was in the first footnote after he thanked others, the sentence that said, "Errors, of course, are mine alone." Mr. Cassell.
I have a question for Mr. Cooper. You seem to do a fairly good job of arriving at an original intent interpretation of these various provisions of the Constitution regulating election processes. What I'm wondering is it possible to develop an original intent jurisprudence around something that's as vague as the First Amendment, or do we have to fall back to other sorts of non-interpretist jurisprudence?
I think that it is. I think that one uses the same tools of interpretation. Perhaps, well, the tools may be different, that you may find the sources in different locations, but the important thing is to secure one's understanding of what the amendment restricts and what one's best and most honest reading is of the intent of those who drafted and ratified it. And one looks at all those things all those evidences that one has to discern that.
Yes, ma'am.
I was coming home toward this event tonight on Caltrain, which goes from San Francisco to San Jose. And Caltrain is suffering an enormous deficit at the expense of the taxpayers. And I just casually mentioned to a conductor that we could really make it up if we had an airport stop for Caltrain. And he said, well, get together a petition, and they'll let you circulate it on the train. And he had to leave to collect some other fares, but he came back, and I said, it won't work if the petition circulators can't also receive funds from those who would like to commit themselves. And he said, no, they won't let you do that. Now, I'd like you to, if you would, comment on this. Is this a public forum or not a public forum? It's a train run at entirely government expense. Can they qualify petitions that you can circulate them only if you don't collect money? I mean, it seems to me there is some relation to this Buckley versus Vallejo as far as financing and political processes.
I'm going to have to yield to the other panelists on that. I'm statutorily restricted to provide legal advice only to the president. I'm sorry.
You discovered that. You discovered that rather late in the program.
Since there were no trains in 1791, the First Amendment is inapplicable to the case.
My guess is we'd probably all have some trouble with that law, those of us who are entitled to speak. Mr. Reese.
Yes, I just wanted to point out and ask for comments.
It's unconstitutional. You can
I think it also depends on whether the train runs on time, which is kind of what I want to allude to about Professor Stone's remarks and also about Dean Ely's comment, which is that, first of all, in order to find a different standard of review for expenditures of cash and the other instances of political speech that he cited, Professor Stone made an assumption to which he later alluded indirectly, which I think is the central assumption that really justifies most of the cases. And I think that Professor Ely made a similar assumption in his justification for campaign spending limitations, which is that there really isn't a very important, a constitutional level difference between government regulating the use of government resources and government regulating the use of private resources. And that ties us nicely into Professor Friedman's theme. If you give that distinction a lot of weight, you can justify at least all of those decisions but the Metro Media case and still say that it's unconstitutional to have any restrictions on campaign financing at all. Now, the distinction that, or the assumption that Dean Ely makes, I think, is a little different, but there's a relationship between the two assumptions that interests me. And it is the distinction really between, or the confusion between equality of opportunity and equality of result. Or it can be stated as a confusion between freedom and equality. And I think personally mostly that the Bill of Rights was designed to protect freedom a lot more than it was designed to protect equality. A different way to say that is it was designed to protect private resources. Again, whether they could have imagined trains in 1791 and figured out what to do about them is for me an easier question than whether they could have imagined a society that had a 44% public sector. And a lot of these problems are problems that have to do with trying to apply provisions that were designed to protect people's private actions to a situation in which most of the action belongs to the government. I can't help observing that, that by the same kind of analysis that Dean Ely would apply to campaign spending. That is, we get the wrong results. In fact, one guy gets to speak a lot louder and a lot more effectively, therefore we don't ultimately serve the purpose of the First Amendment. By that same argument, it seems to me that unusually articulate people should probably be forced to hire dumb people to speak for them. Because if we focus on equality of results and say that's what we're trying to protect, then we're going to get one answer. And if we focus on equality of opportunity, realizing that that is often going to generate inequality of results, that freedom is going to lead to inequality. It seems to me that that really is the central difference between the Stone-Ely analysis of the problems and the Bork, Cooper, Bevier, Madison, Hamilton, Jay analysis.
Way to go, Rocky.
Well, I plead guilty substantially to what you've said. As to the constant tension between freedom and equality, I think to the extent I was talking in terms of a utilitarian individual interest measuring model of democracy, you're quite right. That is a model which cares a lot more about everybody's interests counting the same as everybody else's when you're toting them up, I think, than it does about freedom, I agree their intention. I guess nonetheless, I find that a more coherent explanation of democracy.
But can
not
I
the
ask
only
you a
one.
question, Dean Ely?
Yeah.
How much political power would anybody have if we all had the same amount?
One, I guess you'd have to divide
Well,
the
you'd have
population
one. Wouldn't have any.
You'd have 1/200 millionth of the power, I suppose, and then you would have to, interest groups would have to have power. Groups of people who think alike would have power, and no single individual would have much by him or herself. That's certainly
Well,
right.
but then you'd have to equalize the groups, because surely some would be better at
no,
raising
no,
money
no.
than others.
I don't think so.
Okay.
I don't think that's part of the model I was describing, whatever its other defects.
John, can I respond?
Yeah.
The first point you made about public property and the government's ability to control its resources, I think that is a legitimate distinction. And I was not in any way suggesting that there is no difference between the expenditure cases, which I did not say were wrong, which I don't think are wrong, and the other cases that I dealt with. Rather that I just don't think that difference makes as much of a difference as perhaps you do. And especially in a society where, for better or worse, and many of you may believe worse, government increasingly controls large portions of our resources, that as a consequence of that, it does become more necessary to make those resources available in other ways in order to have an effectively functioning political system. The other point I'd make about simply the idea of equality and freedom and expenditures in a political marketplace is that although I do not disagree with the proposition stated in Buckley, and I think that for the most part that the decision on expenditure issues was right, I don't find it quite as simple as the question suggests. If we are structuring a political system in which we wish to create a system in which individuals participate through debate and discussion in an effort to reach correct or desirable political results, then it seems to me if we imagined ourselves here in a room constituting ourselves a political system in which we were going to have a particular amount of allotted time to debate issues, it seems to me highly unlikely that we would agree here to sell that limited amount of time to the highest bidder in this room. We would probably adopt rules that provided in the typical town meeting sort of way, that we would allocate the time either in a first come, first served basis, or that we would simply say that people who want to talk on one side of an issue would have this half of the time, people on that half the other half of the time. But it's never been traditional in a town meeting setting, or in a faculty meeting setting, or when the judges talk to deliberate on a case, where we sell to the highest bidder the right to speak the longest. And although I don't want to make the argument that dictates results under the First Amendment, it is troublesome to me that this is the one area, in fact, in which in our ordinary lives that we do allow the amount of money you have to have that much of an influence on the way in which we will wind up resolving those sorts of issues.
It seems to me that the gentleman by whom I am flanked can maintain their position only if they have a very strong view, which rests upon premises I don't understand, of what political influence, what kinds of political influence are legitimate and what kinds are not. We cannot conceivably equalize political influence or political power so that every person has the same exact amount. That will never happen. And I think what they're saying is that wealth is particularly suspect, that it is the one kind of influence we don't like, and perhaps we don't like it because we have suspicions about the kinds of views wealth is likely to press upon us. But I don't see why being a dean isn't like, of a prestigious law school, isn't like possessing money, in this way at least. Lawrence Rockefeller and John Ely both have, quote, disproportionate influence, close quote, upon the politics of our time. The deanship, the professorship, the journalist job confers prestige, the ability to communicate, an audience, the time to do those things. And those are all, if one wants to view it that way, disproportionate influences on the political process. And I suppose we ought to start regulating those things as well as campaign contributions.
Well, the question is, to the extent they could be rationally regulated or coherently regulated, would you as a judge strike the law down? I don't know whether we should or not, but the question is whether such an attempt would be unconstitutional. I guess my reaction to Rocky's example of bright people and stupid people is that there are some inequalities we can do something about, and others we can't. The Dean one's kind of tough. I'm inclined to think they shouldn't get anywhere near that, but if they did, it might be constitutional to try to do so. Just to extend Jeff's idea of whether we might sell the time if we constituted ourselves a legislative assembly, even if you think that it might be coherent to think we would, might you think we should require everybody to bring the same amount of money through the door, or maybe not to bring money they did not earn, but rather that they inherited, and therefore effort on their part had absolutely nothing to do with their having? Well, it's a hard issue. Yes, sir.
With regard to Buckley, it seems that only a majority of the Supreme Court supports the decision. And I wanted to know, one, what would have been the proper limit and who should have set that limit for contributions, assuming that a limit should be set. And also, hasn't history shown perhaps that not necessarily in the case of contributions, but in fact that the political animals who can reach a heartbeat away from the presidency can indeed be influenced by $1,000?
Well, I don't have the vaguest idea where the limits should be set. My view only goes to whether the court should strike down what Congress has decided the limits should be. It's really a view about the courts restraining themselves. I'm not even sure I think the law is a good idea. But
I guess that since I've been in law school, I've heard no word more than reasonable. Professor Stone, you suggested that the test for determining whether or not a law, I think you were referring that time to state laws restricting speech, should be reasonable. And I'm just wondering if that might not allow a judge's particular political or ideological predilections to play too large a role in the decision.
Incidentally, after you leave law school, you'll hear that word frequently, though it'll be followed by attorney's fees.
The court has, one of the things that's striking about constitutional jurisprudence, to the extent there is such a thing, is that the court seems always to try to avoid reasonableness or balancing, if it can avoid it. As you see definitional judgments that are made in which the court tries to say either you need a compelling interest or any conceivable rational basis is okay. And one of the reasons for that is unpredictability. Another reason for that is because of the inherent subjectivity of that kind of an inquiry. On the other hand, there are simply some matters that can't be resolved by a kind of black and white approach, that it's always okay or it's never okay. Life isn't that simple. And the Fourth Amendment uses the word reasonable explicitly, or unreasonable explicitly. And although I tend to agree with the notion that it is not an unmitigated good to have courts deciding what is reasonable, it seems to me sometimes it's better to have courts decide what's reasonable than to give no deference at all to legislative judgment or to give complete deference to legislative judgment. Those are three crude choices, and amongst them, each one is best sometimes.
But Professor, on the other hand, aren't there plentiful textual, jurisprudential, and doctrinal tests which could be employed to set a more specific standard than reasonable? Why? It's not the Fourth Amendment. The First Amendment doesn't say anything about reasonable. It's just not there. And as Professor Cooper pointed out, in the case of federal exercise, I'm sorry, not
You've been promoted.
Mr. Cooper.
That was most unreasonable.
Thank you. Congress, it just isn't granted a number of powers. Their powers, rather, are very restricted by the words of the Constitution. So why would you even need to resort to a reasonableness test in this situation?
Ever. You mean
Ever.
ever?
It's a test for the rind.
Just for the rind. Okay, right. Just for the rind. No, I think that's a serious answer. I think that's a serious answer.
I thought it was true.
Yeah, I mean, the point is that there's not every, even if one limited the First Amendment to Congress and forgot about incorporation, forgot about the states, not every law that affects freedom of expression can be either held to be unconstitutional automatically because it affects freedom of expression. I mean, you could do it, but it would be a crazy world, and it wouldn't make any sense. And no framer would have intended it. Nor could one say, no reasonable framer would have intended it. Yeah. I mean, the world is simply too rich, I think, to have the kind of simple notion that you would like it to have. It would be nice if it could, but I don't think it ever can.
Thank you.
I'd like to have one more go-round on the money talks issue. I was wondering if Judge Bork would expand on his remarks a bit about political contributions being speech. Do you draw a literal equation there? Because presumably if someone actually bribes someone, that's sending the message in a very special way, I believe, strongly enough about this that I'm willing to engage in what's held to be corrupt behavior. And how do you stand on the enunciation amplification difference? Does the right attach simply to making known that you feel as a citizen this way about a particular issue? Or do we go back to Professor Friedman's marketplace in some way, and you have some market advantage? You have a right not only to advertise your belief, but to advertise it to some volume that's effective.
Yeah, I don't know why I don't see why the bribery question comes into it at all, unless we're talking about prophylactic rules. I mean, nobody denies that bribery can be made a crime. But if we're talking about prophylactic rules, because contributions of a certain size are likely to be bribery, I would think, one, that is a proposition that is almost always untrue no matter what size range you pick. And secondly, that you would have to choose a size range if there were any much, much higher than anything contemplated by current law. No, I think the important contribution of the importance of the contribution is not just to symbolize your agreement with the speaker, but to enable somebody who is much more persuasive than you are, who is going to articulate the ideas you want articulated, and who has the time and will make a career of articulating those ideas, to enable that person to be effective. So it's a question of getting speech out effectively. Given the disagreement among people in our society with money, there is no danger that any major, even minor point of view is going to go unfunded. In fact, as we know, some very wealthy people fund some very radical causes. So I simply don't see the real danger to democratic processes from contributions of almost any size. In fact, I think they serve a valuable function.
Yes, Mr. Cooper, I wondered if you could give us some idea of how an original intent interpretation would handle the question of sedition. We know that the founders and the founding generation did have some acquaintance with federal law concerning sedition, and I wondered how you, in the present day, would use a original intent interpretation to handle questions of sedition, that is, speech or press activity that threatened the reputation of government officials or of the government itself.
I don't think there's any question that a federal statute such as the one you cite would be unconstitutional. Absolutely, absolutely. It seems to me that would pretty clearly be a regulation abridging the freedom of speech. I don't think that's a hard question.
Not the good ones, though.
There's no way to square that conduct with the plain language, the text of the Constitution.
I don't think that there's any way that one can truly believe in original intent and regard the question of seditious libel as an easy one. I mean, it seems to me that it's quite clear that seditious libel is an extremely difficult question for anyone who takes the issue of original intent seriously.
If
Yes,
I can
ma'am.
bring Professor Friedman's shadow back over this panel again just a little bit, why aren't these laws like some of the most dreadful kind of regulation that we have in government, and to the extent that they're distorting what might be a normal market process if it were left alone? I don't direct that directly if no one wants to answer. I suppose that's
Well,
fair, too.
I take it that that's much of the argument of the people who think they're unconstitutional. I suppose those of us who are trying to defend them would say that distortions of market process are often constitutional, that there is no, that the stronger textualist than original argument against them would be one specifically tied to the First Amendment rather than one that comes from a meta principle that you can't interfere with markets, which is not ordinarily thought to be part of the Constitution. And just wait a while, yes. Yeah.
I was just wondering, perhaps this is better directed to Mr. Cooper and Judge Bork and Professor Bevier. Just there seems to be a lot of, well, especially from coming out of the Office of Legal Counsel in the White House, and certainly Mr. Cooper tonight has been talking about getting back to the original intent and the intent of the framers and the text of the Constitution as somehow something to aspire to, because that's a better way to solve these problems. And what occurred to me is that the original people that founded this Constitution, many of them, Madison, Hamilton, Jay, were Federalists, and that the text and the original intent is really appealing to the Federalist doctrine, and whether the fact that you are, I don't know if you're members of the Federalist Society, but you seem to have the same views, are arguing that you should return to the Federalist intent, isn't really just kind of an advocacy position that these are the views you hold and these are the people that shared them. And in that sense, is it really a position that is more justified, or is it something that you just believe?
I think he was looking at you.
Well, I have to confess that an application of the jurisprudence of original intent oftentimes, in my view, yields a outcome that I favor. But that is by no means always true, and it's certainly not the reason for adhering to that theory, to an interpretivist view of understanding the Constitution.
After all, he said original intent would strike down the Alien and Sedition Acts. Now that certainly can't be what he wants to happen.
No, let me just say, but the argument for original intent really, I think, begins and almost ends with the fact that there is no other way to call the Constitution law in any sense that is external to the will of the judge. If you're looking for something that will provide guidance not only to the society but to the judge and constrain the judge's will, I can think of nothing other than the search for what the people who wrote the provisions and ratified the provisions were trying to accomplish.
John, can I agree with the idea that original intent is central, if not exclusive, to the idea of what the Constitution means. But the notion of what we mean by original intent seems to be taken in some quarters these days in a highly simplistic way. Imagine, if you will, that you were the group who had voted upon and adopted the Equal Rights Amendment, and that I were to ask you, a year after the Equal Rights Amendment were adopted, what it is that you intended this amendment to do with respect to the question of women in the military, or women being drafted, or unisex bathrooms, or a whole range of other possible issues. Most of you would probably have particular ideas as to exactly what you meant in voting for the Equal Rights Amendment. Now let me ask you what it is you would answer if I said, well, what do you want the Equal Rights Amendment to mean with respect to those issues in the year 2186, 200 years into the future? And I suspect that if you were at all thoughtful and intelligent, you would say, I don't have the faintest idea what I want the Equal Rights Amendment to mean in specific terms, in terms of unisex bathrooms, or women in the military, or women being registered.
That's why it was such a bad amendment.
The same, you know, would be true for the First Amendment, or the Fourth Amendment, or the 14th Amendment, all of which also, no doubt, you regard as bad.
No problem, right? The 19th was a good amendment, no problem.
We should have limited ourselves to the 19th. To finish my point, it's that if one asks what one means by original intent, it seems to me one has to ask an honest question, not a dishonest one. And the honest one is not what did they immediately expect the amendment to do in their world, but what would they intend that amendment to do 200 years down the road? Now, I don't purport to have a simple answer to that question, but that seems to me to be the question of original intent, not what did the framers intend 2 days later, which would not have been the question they would have asked themselves.
Okay, we're going to have two more questions only by the two people standing at the
May I just say
microphones.
before this question, that I know of nobody who takes the view of original intent that you have just destroyed.
Which one is that?
You destroyed more than one?
I thought so.
One of specificity in exactly what does it mean with respect to this circumstance. Nobody who espouses the doctrine of original intent takes that position.
But it does seem to me that that if one would apply an intent that is plainly and clearly not within the contemplation of the founders, one would have to invoke the mechanism under Article 5 to amend the document.
That assumes you know what they contemplated or intended.
Sometimes you do.
Sometimes, I agree, sometimes you do. But most of the time you don't.
Yes, ma'am.
Actually, Judge Bork just addressed this question, but I was going to ask it of Mr. Cooper. You spoke a lot, well, you started your talk by saying first that as a member of the Reagan administration, you were morally obligated to speak for the position that intent had sort of special status as an interpretative guide. And then you went on to talk a good deal about the content of intent, sort of suggesting that the criticism that intent could not be ascertained was one of the criticisms of using it as such a guide for interpretation. I wondered if you could say a bit more about why intent does deserve that special status, independent of whether or not you have difficulties ascertaining its content in particular cases.
Well, on that, I would simply invoke what Judge Bork has already said. I think that intent is more than just a useful guide. I think it must be the framework. The guides, useful guides to divining intent, are things like the text of the Constitution. I quoted a few passages from the Constitution with respect to the political process that to me seem rather unambiguous. The other evidences of congressional intent that relate to those provisions would support the plain meaning of the words that they used. In that context, to depart from the meaning that is displayed on the face of the Constitution and permit the federal Congress to set voting qualifications for electors, let us say for the presidency, is in essence to consign to any collection of 5 Supreme Court justices our future. And I don't think that's what the framers had in mind. It's certainly not my idea of of constitutionalism.
Yes, sir.
This is also a question on original intent, and since everyone on the panel seems to have an opinion on it, I'll open it up to anyone who cares to reply. Isn't there a danger if one adopts some sort of original intent jurisprudence or original intent as a factor in deciding in the way we should interpret the Constitution, that one will either have to argue to support this original intent theory that the people who framed the Constitution were so superior in knowledge, insight, and wisdom to anyone else who has existed in American history? Or is there also not a danger that those who wish to attack a specific policy position which has been taken by a court and which has been justified under original intent, rather than attacking the argument itself, will attack the ad hominem, the framers of the Constitution? Isn't there a danger of, in original intent analysis, of putting the people who wrote the Constitution on a special plane? And of course they are on a special plane because they wrote the Constitution, but as has been pointed out in numerous instances, there are a couple of things that have happened since 1791 that they did not contemplate, mainly because they could not have contemplated them. And so I'm just going to open up that free-for-all.
I'll just say that it's always dangerous to interpret the Constitution. There isn't a single issue involving the allocation of power to decide the kinds of issues that are at stake that isn't dangerous. I mean, there isn't a single interpretive theory that doesn't have inherent dangers. And if you're trying to suggest that the Constitution is law, in some sense, and law, most importantly, I think we often get real mixed up about what the constitutional law is really about. We think it decides the merits of controversies, and really its most important function is to tell us who the decision maker is. Okay? Who decides, not what do they decide. And we get all head up about merits questions, and I think we ought to pay more attention to the who decides question. The Constitution forecloses very few results, in fact. It's quite a permissive document. It's just that the kinds of results, the ability to make mistakes has been allocated in particular kinds of ways. But it is a dangerous game. It's a dangerous game to try to run a country and govern a people.
The rest of our panelists have all come from the East, and therefore it's very late at night for them. I, of course, would love to go on forever and ever, but it wouldn't be fair to the others, so we're going to close it off right here. Be here at 9 in the morning and learn all about religion.